The broadcast is now starting. All attendees are in listen-only mode.
All right, hello and welcome to the Micklin Law Group's monthly webinar series. Micklin Law Group is a law firm concentrated in men's and fathers' rights in divorce, family law, and custody matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. Just going to make sure that we're recording okay before I jump into it. It looks like we are. It's just not telling me. So let's move right into it with the hopes that this is going correctly. Hello to those that have not worked with me. This is me. My name is Brad Micklin. I'm the lead attorney and managing member of the Micklin Law Group. Been a practicing attorney since 1996. As I said at the intro, our firm is concentrated in empowering men and fathers in divorce, custody, and family law matters. There is a QR code on the screen that is for my online calendar. You can book a slot if you want a consultation. You'll be then prompted to contact the office to schedule an intake and then move forward on a meeting with me. I've also been honored to serve as a national legal consultant on various national and international news syndicates, Fox News, Inside Edition, I-24 International, Larry King, may you rest in peace. I say this not to impress you, but to impress upon you the wealth of experience that I hope I bring to my cases and to your matter if I ever had the pleasure of working with you specifically. Also had been honored to receive certain accolades and awards from both client and colleague testimonials. Here's a few of them again, just to let you know the dedication I put into my work and the knowledge that I bring to it. So let's move right into it, cracking the alimony and child support code in New Jersey. Navigating the complex world of alimony and child support in New Jersey can be a daunting task, but with the right legal guidance, you can ensure a fair and equitable outcome for your family. In this comprehensive webinar, we'll explore the intricacies of the legal landscape and provide you with the knowledge and tools to make informed decisions. First, understanding alimony in New Jersey. Eligibility, modifying alimony, and the different types. First, eligibility. Factors such as the length of the marriage, financial need, and the ability to be self-supporting are considered in determining alimony. There are actually 14 different factors. I think another site, another page in this webinar may go a little more in depth. But of the 14, the ones I speak of here are going to be the most important. They are the length of your marriage, the lifestyle that you shared, the paying spouse's ability to pay, and the needy, for lack of better words, the needy spouse's ability to earn. Modifying alimony. Alimony orders can be modified due to a change in circumstances such as job loss or retirement. The general standard is going to be a material and substantial change of circumstances. This will depend, and we'll go into this again later, on the type of alimony that you have and the way in which it was ordered, meaning was it ordered by a judge at a trial or was it agreed upon in a settlement, which would then dictate the terms for modification. There is also a recent case that held, oh, by the way, this is being recorded in New Jersey on July 12, 2024. So if you're outside of New Jersey or listening at any time substantially later than this date, these issues may have changed a bit. Generally not so much so, because I try to make these webinars broad in its spectrum and pragmatic in its application, which means I speak generally about principles and practically, as opposed to citing specific cases and facts, because they do change quickly. But that being said, there was a recent case that held that a change in parenting or custody can be a change or a reason to seek a modification to alimony. It's not surprising they finally got around to realizing that if you're taking on or giving up significant custody responsibilities, you will have more or less time and more or less of a need for support. And then the types of alimony, New Jersey recognizes several forms of alimony, including open durational, limited duration, and rehabilitative alimony. Open durational is what used to be considered permanent. We did away with permanent because of the ability to modify it, as we mentioned above. So now it's called open durational. The law says if your marriage is not more than 20 years, your alimony term cannot be longer than your marriage. That's a little ambiguous because it doesn't say just the opposite, but I think that's the intention. It generally does get modified, as I mentioned, at retirement, unless you otherwise agree. What isn't mentioned here is term alimony, because most people don't really think about term alimony. They think of it more like limited duration, which is a fixed duration. But terms of alimony, if you agree to just a fixed sum of alimony for a fixed time, then that's term. And it may pay you to put that word in agreement because it will change how it is modified or whether it can be modified. Factors considered in alimony determinations: financial needs, standard of living, and earning capacity, to name a few. Financial needs. The courts will examine the financial need and resources of both spouses, including income, assets, and expenses. So again, this goes to the ability to pay from the person who earns more and the ability to earn from the person who earns less. Issues will include employability, past income history, education, child responsibilities, and many other things. Standard of living. The court aims to maintain the standard of living established during the marriage within reason. Now, they use words like comparable life, and here we say within reason because there's never a comparable life when you get divorced. You have one house with one or two incomes, generally becoming two houses with the same one or two incomes. So things will change. There's no such thing as comparable. Or at least people like to think comparable means equal, and it doesn't. And comparable, even that's, I think, a misnomer in a divorce. And then earning capacity. The earning potential and ability to be self-supporting are crucial factors in alimony determinations, now and in the future. So often, for instance, alimony may start out larger and then become smaller over time because of the person's ability to increase his or her earning capabilities, education, or reducing childcare responsibilities. Types of alimony in New Jersey, as we touched on above, we have open durational, which is awarded in long-term marriages with no predetermined end date, although generally in practice it will end or be modified at retirement. To limited duration alimony, granted for a specific period of time, typically to allow the recipient to become self-supportive. This type of alimony generally cannot be modified to extend the duration, but can be modified to increase or decrease the amount during the limited duration that's been set. Rehabilitative alimony provides temporary support to enable the recipient to obtain the education or training necessary to become self-sufficient. This may be going back to school or taking a certification programming, coming up to date on computer skills and technology. Rehabilitative alimony, usually referred shortly as rehab alimony, can be modified for length or amount if the circumstances that were contemplated in the award do not come to fruition. For instance, if you're agreeing to a 4-year alimony award, rehabilitative alimony, so the person can go back to college, and that person doesn't finish college for some reason beyond their control, for instance, then possibly the rehabilitative alimony could be modified and extended. Reimbursement alimony compensates a spouse for financial contributions made during the marriage, such as funding the other spouse's education. This is an often overlooked part of alimony because it's generally due to the person, or owed, I should say, not due, but meaning owed to the person who is earning more in a marriage. Meaning the common situation is one spouse supports another spouse in obtaining an advanced degree. That spouse then gets divorced, and the other spouse who got the degree now has this asset, the degree, for which he or she will earn more money in their future. So reimbursement alimony is a type of repayment for that sacrifice, for the fact that the new spouse, not the new spouse, but the new degree is going with the other spouse. It's often used as an offset. I've never seen a case where there was a specific payment of reimbursement alimony. It's usually as an offset to an alimony payment that person will be making to the other spouse, but plenty of circumstances where it could be vice versa. But it's something just to keep in mind because, like I said, it's often overlooked. Calculating child support in New Jersey, which, by the way, I have a number of webinars I forgot to mention in my past slides as well as this, dealing with the different types of alimony, dealing with how to calculate child support both theoretically and practically, as well as many other webinars at Brad Michael Micklin. It's also my website, micklinlawgroup.com, which I'll probably reference once or twice before we conclude. But after this, if you have additional questions, I would certainly recommend going to my website or my YouTube page for additional videos. That being said, calculating child support in New Jersey. Income determination, child support guidelines, and deviations and adjustments. Income determination, the court considers the parties' incomes, including wages, investment returns, and other sources of revenue. All income is considered, whether it's received through physical efforts, like a job, or if it's received through investment vehicles like interest, inheritances that generate principal drawdowns or interest income. It is presumed, the guidelines are presumed to be correct. It's a mathematical calculation. The New Jersey Child Support Guidelines provide the framework for calculating the appropriate amount of support. It basically is a calculation where it plugs in both the person's incomes, a parenting schedule, whether or not there's health insurance, recurring medical expenses, or child care, that all gets factored in. Then it calculates an actual payment to one of the spouses in most circumstances, or sometimes when you're sharing custody or there's agreement otherwise. But generally speaking, the guidelines are going to be presumed and calculate an actual number. As practice, it usually represents somewhere between 10 and 13% of your gross income, which to the person paying probably sounds like a significant amount. The reason I can't go into in depth, because it takes a very long time, but you can get in my other webinars about child support, is the types of expenses that it's intended to cover. It includes your fixed, variable, and controlled expenses. For the definitions of those and how they apply, again, see my other webinars. I will try to put links down below to those webinars. The problem I have with the child support calculation is that it will be the same throughout the entire state. And generally, costs of living and even incomes, I think, vary significantly between South and North New Jersey. But this has not been contemplated, or at least doesn't seem to be contemplated in the guidelines. Deviations and adjustments. The courts may deviate from the guidelines based on factors such as special needs, shared custody, and other unique circumstances. More often than not, deviations are made by agreement between the parties. The case law suggests that you should include a statement as to why and how you deviated, so that when it's reviewed later, the court will understand whether or not such deviation should continue or not. Sorry, I just had to get a message out. Modifications to alimony and child support. change in circumstances, cohabitation or remarriage, emancipation of children, and retirement are the most common. Changes in circumstances, alimony and child support orders can be modified if there is a substantial change in financial circumstances of either party. And that's important to remember because you may be paying it, but if the other spouse's income increases, he or she can seek an increase. Similarly, if the other person who's receiving alimony loses income, they could possibly seek an increase in support. There is a case, Lepis versus Lepis, which determines whether or not change of circumstances warrants a change in alimony. Won't go into that again because it's outside of the scope and a little extensive. But if you want to read up on that, it's Lepis versus Lepis. You can just L as Larry, E as in Edward, P as in Paul, I, S as in Sam. Typing just those words, Lepis versus Lepis, should more than easily pull up the information about that. It's a very common, very old case. Cohabitation or remarriage. Court may terminate or reduce alimony if the recipient cohabitates with a new partner or remarries. I also have a webinar on that. Very convoluted, especially under the new case law, because the reformed alimony statute now allows you to modify or terminate for cohabitation. But if the cohabitation ends subsequently, then it can possibly be reinstated, which I think is absurd. But that's the way the statute reads. In practice, I've never seen it happen yet. The reform was alimony statute was modified in 2011, I think, or 14. Haven't seen a reported case, haven't had a case where that's actually happened, but it's certainly a big risk. And it's important because you may go through a great deal of cost and legal proceedings to get a modification because the other person is cohabitating, and then end up going right back and terminating the cohabitation and seeking alimony. And it's a very unsettled area of the law. Emancipation of children. Child support obligations typically end when a child reaches the age of majority or becomes emancipated. Tip now in New Jersey, child support will automatically terminate at 19 unless a party moves to extend it. It will almost always be extended if there's college. And in New Jersey, child support does not necessarily always terminate. Some children have needs, special needs, educational, physical, mental, psychological, psychiatric, many of them, that cause them to need further or sometimes permanent child support. In those cases, they receive child support further or permanently. Retirement alimony can be modified or terminated when the paying spouse reaches retirement age and their income changes. Interesting question that arises with that is I've never seen a person ask for or be awarded a termination of child support at retirement, presumably because most people's children are of sufficient age before they get to retirement age, but that's not necessarily a general rule. I think as people get married and have children later, we might start to see this issue more and more often. Enforcing orders for alimony and child support. Court orders, enforcement mechanisms, and contempt of court. First, alimony and child support are legally binding court orders that must be followed. As an attorney, that's often difficult. My job, I always have to and always do tell my clients you have to comply with an order, even if it's grossly in excess of your ability or your available funds. We have no ability to tell you not to follow an order. Enforcement mechanisms. Non-payment can result in garnishment of wages, interception of tax refunds, and other enforcement actions, including arrests, suspensions of your license and passport, and other mechanisms. Generally speaking, arrests, although they happen and they're often administrative, which means the orders just go in and the judge signs them in a pile. So it's hit or miss. Some people will be arrested for $100. Some will not be arrested when they have tens of thousands of dollars. It's, like I said, hit or miss. But in my experience, when you appear before a court, the sanction of arrest is rare because that usually means that there will be no money to be paid if you're in jail. Not to use that as a way to avoid obligation, but just so you know how to plan if you find yourself in an unfortunate circumstance. And contempt of court. Willful failure to pay can lead to a finding of contempt of court and potential fines or jail time, all of which I just mentioned. The best defense to avoid this is to obviously comply with the order and pay as what you're ordered to. But if you are not able to, for whatever the reason may be, I always say you got to send in something. If you send in $5 a week, $10 every other week, $50 a month, anything that shows you're making a consistent effort, courts will generally, judges will generally not sentence you to jail because they see that you're trying and they see the other spouse is getting some money, and some is better than nothing. Navigating the landscape with confidence. Balance. Achieve a fair and equitable outcome for your family. Make informed decisions with the right guidance. Work with a knowledgeable and compassionate attorney, although it may be difficult to find. And secure your future by protecting your rights and safeguarding your family's well-being. The whole point of this brief webinar is to give you the framework for how alimony and child support works practically. Do not try to handle these issues on your own if you have the means to get an attorney. If you don't, at least consult with several. Most attorneys will give you free consultations. It's certainly good to get some free advice. As I've said repeatedly through this webinar, I have a plethora of resources, both on my website, micklinlawgroup.com, MICKLINLAWGROUP.com, and my YouTube page, Brad Michael Micklin. They are free resources. They will cover great in-depth issues of everything we touched upon and many other things. But don't go at it alone. It is complex. The repercussions are significant. And, the recipient of the support and the children need what they're getting and are entitled to get it. So you want to make sure that everybody is protected. If you want to contact the Micklin Law Group, if you need legal assistance with a family law matter in New Jersey, you can contact me, Brad Micklin, Esquire, and the Micklin Law Group. As I said, you can visit our website at micklinlawgroup.com, MICKLINLAWGROUP.com. You can call us at 973-562-0100, or as I keep saying, check out our YouTube page for more information and resources. We are, obviously, like everybody else, on social media. In addition to my YouTube page, which I mentioned at nauseam here, I do have a Facebook page where we post blogs, and you can post comments. I do my best to respond. I am on LinkedIn. I do the same. I post blogs and I respond to comments. I don't do a lot on Twitter. I do believe I have a Twitter page or handle or whatever they call it, but I can't remember last time I used it, so I don't recommend going there for my materials, at least. And the infamous legal disclaimer: I will not take your time to read all of this. The most important to remember: this is not considered legal advice. It is advertising. It does not create an attorney-client relationship. You cannot rely on this information. That is the purpose of a consultation, so that you sit one-to-one, get the real information, and give the real details. That being said, I hope this brief webinar was helpful to you. If I can be of any service to you, again, call my office at 973-562-0100, or use the Q code at the beginning of this, which I think is also on my website, and schedule a consultation with me. Thank you and be safe.